Generally speaking, an employer can be held liable for the acts that it authorizes its employees to do or acts that are closely connected to its employees' work. And so what that means is that if an employee of a company were to cause somebody harm, not only might that employee be held responsible by the person who was harmed, but the company that they're working for can also be held liable. And there are a few reasons for this. The first, deeper pockets rule. Generally speaking, in tort law, again, it has a compensatory function for the person that's harmed. There needs to be a good path of remedy for the person who has been harmed, and you're much more likely to successfully sue or get paid out by a corporation than an individual employee that's working there. Another is deterrence. We talked about some of the benefits of strict liability in promoting safe practices in the workplace. And vicarious liability does the same thing. It encourages employers to hire really good people, train them really well, and have really good procedures and safety protocols in place to ensure that harm doesn't result from the work that they're doing. Finally, it's just good old plain and fair, and that will come into play a lot in the law, which should be a really comforting thing. It simply wouldn't be fair for a company to play a role in somebody's harm if their employee did something in the course of their work and yet be off the hook from any liability. And so by simple way of fairness, companies can be held vicariously liable for the acts of their employees. Which begs the question, who is an employee? This is a more complicated question than what is on the person's business card or email signature. Because otherwise, businesses would be able to avoid vicarious liability really easily by just calling everybody a contractor. So courts will look into several factors when trying to determine, is this an employee that you would be vicariously liable for, or is this a contractor who is liable for themselves? And courts will look at things like control over the project and how it gets done, use of property and equipment, whether that is the contractor's personal equipment or they're using the organization's equipment. They'll look at the pay schedule. So are you paid regularly like an employee or intermittently or in sums like a contractor? And they'll also look at the degree to which that person has been integrated into the daily work environment of that culture. And then when looking at all of those things together in a particular fact scenario, the court will decide for the purposes of the law and vicarious liability, would this person be considered an employee or an independent contractor?